Good morning. You're watching Do I Need a Lawyer? I'm Gary Martin Hayes. Thank you for starting your day with us. Now let's get to a question from one of our viewers regarding workers' compensation claims here in Georgia. Gary, I seriously hurt my back on the job about a year ago. When the physical therapy and epidurals did not relieve the pain, I chose to have surgery. They did a lumbar fusion and it certainly helped, though I still have pain and limited movement. I'm still going 3 times a week for physical therapy. Here's my concern or question. The employer called me and wants me to return to work next week. I've been returned to light duty as the doctor says I can only lift 10 pounds and I shouldn't bend or twist. I'm afraid what my employer considers as light duty is not what the doctor feels is light duty. Should I return to work? If I do, what protections do I have and do I need a lawyer? And the question comes to us from Demetrius in Villa Rica. Demetrius, thank you for the question. And I'm very sorry to hear about your on-the-job injury and the accident, and I hope and pray that you continue to improve. Let me tell you what the law requires of employers and insurance companies when the doctor returns you or any other worker to light duty work after you've been totally disabled and receiving workers' comp checks. Now, the law that applies to these return to work situations is Official Code of Georgia, annotated section 349240, and Board Rule 240 also explains this. It says, if the authorized treating physician releases a worker to light duty after they've been totally disabled and receiving workers' comp checks, the employee is not required to go back to work and try this light duty job unless and until the employer and the insurance company do 3 things. 1, the employer and the insurance company has to send the authorized treating physician a description of this light duty job to be performed, including the hours to be worked, the rate of pay, and the description of the task to be performed. Now let me point out a couple of other things about this light duty job description. Whenever the employer and the insurance company sends it to your doctor, they also have to send a copy of it to you and your attorney at the same time. This is very important. If we receive a light duty job description, we immediately call our client to see if this is an accurate description of the job. If we don't agree with the description of the light duty job, or if we have reservations about our client being able to do this job because of their injuries or because of their medications, this gives us a chance to speak with the doctor and voice our objections. Also, the board rule requires that the injured worker have been seen by this authorized doctor within the last 60 days before they ask the doctor about the employee's work abilities. Number 2, the authorized doctor has to approve the light duty job for the injured worker. If the doctor says, no, you can't do it, I don't approve it, then the worker does not have to return to the light duty job. And 3, if the doctor approves the light duty job, then the employer and the insurance company have to send to the injured worker and to us as their attorney a WC-240 form. And you see a copy of the 240 form here. This is a notice to the employee that this light duty job is being made available to them. The doctor has approved the job, and this is the date, time, and place that a report to work. This notice has to be sent with 10 days advance notice to the worker and to us as the attorney. Let me explain to you why this law is important. The last thing I want, or the last thing the State Board of Workers' Compensation wants, is for an injured worker to be forced to return to work doing something that could risk re-injury, an aggravation of the injury, or put others at the job site at risk of being hurt. We want to know that the doctor thinks the employee can attempt the job without any of those risks being present. So if a client of mine is released to return to light duty work, I tell them, do not go back to work unless and until the employer and the insurance company comply and complete this WC-240 form. Now here's another question. What happens if you go back and you try this light duty job, but because of your injuries, your pain, your physical limitations, you can't do the light duty job? What happens? Well, it's a great question. The law says if you go back and you attempt this job for more than 8 hours or 1 scheduled work day, or if you're unable to perform the job for more than 15 working days, then the insurance company has to immediately reinstate your weekly checks, period. Let me tell you what this means in layman terms. This essentially means that the employee has to try this light duty job in good faith. You have to work more than 8 cumulative hours or 1 scheduled work day. So for example, if you go back and you leave after 4 hours of work because you can't do the job, the insurance company doesn't have to start your workers' comp wage checks immediately. More than likely, the injured worker may have to ask for a hearing to get the benefits started. Here's another example. You go back and you work more than 15 working days. Say on day 16 you decide you can't do it. Again, the employee has the burden to prove you can't do the job because of your physical limitations. And the insurance company is not going to start your workers' comp wage checks up voluntarily. One final example. Assume on day 3 you just can't physically do this light duty job since it's more than 1 working day and less than 15 days. The insurance company has to start paying you your workers' comp wage checks immediately. Now, as you can see, these workers' compensation claims are extremely difficult and complicated. This is certainly one area of the law where I encourage you, do not go it alone. Do not take on the insurance company and their lawyers by yourself. Listen, we specialize in workers' compensation claims. We would be more than happy to discuss your claim with you. The call is free, completely confidential, and there is no obligation. Give me a call, 770-934-8000, or email me, Gary@GaryMartinHayes.com, and we'll be right back.